So you're looking at a case against a nursing home, and the client tells you that there was 3 falls, and finally on the 4th fall, their mom split their head open or had a subdural hematoma, rushed to the hospital, and sadly died. You get the chart, and there are some notes about a fall, but not really anything saying what happened. Then on the fateful day where the head injury occurred, there's a very brief note saying there was a head injury and sent to the hospital, but there's nothing else there. Well, what do you do? How do you handle that case? My name is Saul Gruber, and at Gruber Trial Consulting, we help lawyers all over the country handle their nursing home cases. And when we do that, one of the key things we say is you're going to need the incident reports in order to determine if a case is even viable. Now, we know that both the federal regulations, which I've spoken about previously in a different nursing home minute, as well as the state regulations, will all mandate that certain types of injuries have to have an incident report. We know that the policies and procedures of every nursing home will also say there has to be an incident report. In fact, every nursing home's policies has with it a type or a style of incident report that's supposed to be used. Now, you take it further that whenever there is a fall or an injury of an unknown source, or one that could come as a result of either neglect or abuse, the nursing home must contact the state Department of Health and report that incident. That's known as a reportable incident. And each state has a reportable incident form. Knowing all this, how is it possible that we don't get those incident reports in pre-suit? You won't. You never do. And it doesn't matter how many times you ask for it. So one of the key things you have to do when you have that situation is file a lawsuit. In some states, you can file for a pre-suit discovery or file a lawsuit just to get the incident reports, but that can be pretty dangerous as you're not setting the record on why you're entitled to the incident reports. And in the states where there's peer review and peer review is not discoverable, a judge may reject you right away. And that could be a real big problem. In other states, of course, there is law that simply says incident reports are not discoverable. However, I still think there are ways to get pieces of those reports, even if they're redacted. So what do? Well, you file a lawsuit, as you would in any case. Then you lay the trap by starting with the deposition of the administrator. Whether you do so by a corporate designee records deposition or simply by their deposition is up to you. But what you're going to ask them specifically is, are there things such as incident reports? Why do you have them? What is their purpose? Do you agree that you must keep them based on this regulation? Do you agree you must do them based on this statute? Do you have a policy about incident reports? Is that one of the reasons why you also do the incident reports? So you want to lay the foundation that it's not just peer review, it's a lot of other reasons that they do the incident report. The next thing you want to do, especially in the case where you have 3 falls, then the 4th fatal flaw, is in those 3 falls, when you do the incident report, is part of the reason you're doing this report is to see how you can stop this from happening again. And do you agree that if you come up with ideas of how to stop it from happening again, that would then go into a care plan for this resident? And do you agree that if you come up with reasons in the incident report of how to stop this fall from happening again, and it doesn't make the care plan, that could be a deviation of the standard of care? So then another reason you're doing the incident report is for the care and safety of this resident. Now you're setting the stage that it's not peer review, that it's not just to notify the state, it's to render care. And if they don't do it to render care, meaning they don't take the information in the incident report, put it in the care plan, that could cause injury to the person. And in fact, that's what we're trying to show here. Now, you're going to be met with a lot of objections, but keep at it. Keep diligent. Keep using the right ways, not I want it, judge, not it's not fair, not how else will I know, but the right ways, and set the predicate in a deposition. Then you can use the information in the transcript to get the records. And don't be upset if you're only getting the facts. That will go a long way. And don't be upset if you're getting the names and any statements that were given. That too can go a long way. If you have any questions about incident reports and how to lay the predicate, please feel free to call us. If you like this Nursing Home Minute, please subscribe to our YouTube channel so that you can get all of our weekly videos, or at least you get alerted as soon as they come out. Also, look for our podcast, The Jury Thinks What, everywhere you get podcasts. It's on the Lawyer Minds ecosystem. And again, if you have any questions, have any problems, please call us. We're here to help.